for you on that. To follow up, let me allow him to ask the next question, or to disagree with you or agree with you. Isaac, you have the floor.
Kaka has made a very spirited presentation, raising dust on our prize. I want to defend our judgment. Kaka, um, you began well by asking us to conceive ideas beyond the realm of legal formalism and probably transcend into political transformation and so on. Um, I agree with that thesis, of course. However, while we are still here, I just want to say that perhaps we have confused human rights and politics. My good friend Kalundi Serumaga has written a year-end article that I should recommend to people on the space, where he says that for now, 40 years actually, nearly 40 years, there's been a group of Ugandans that have confused human rights and politics, and that is why they welcome the NRM regime, which showboated into Kampala using the language of human rights. Yet, as Kakaira says, Kakaira has told us quite vividly, and we agree with him, it was a military gunship showboating into Kampala. Why did we believe them when they were saying they were here to change the track record of human rights in the last so many years since independence and so on? I think Karundi Serumaga has made a far better presentation than Kaka's. So some who may not have understood Kakaira, I do understand where he's coming from. I just disagree with the dust and shade he's throwing at this judgment. Does this judgment make a milestone in human rights from a strictly human rights perspective, stripped of human rights? You see, we shall discuss politics and its content and its trajectory on another day. But from a strictly human rights perspective, does this judgment make a milestone? Is there a novel principle of law? The answer is a resounding yes. And this was contemplated at its drafting. You will notice that it was a very thinly drafted petition, isolating from the entire travesty of the Computer Misuse Act a single section, and testing it as against a single section of the Constitution, even though we could have done more. And I thank Jessica Kuru from Show for showing that the injury to the Constitution transcended Article 29, Sub-Article 1A on media and made a freedom of expression and freedom of speech, and it entered into fair hearing guarantees under Article 28 and elsewhere. What is that noble principle of law? Colleagues who may be lawyers and even non-lawyers, there is something to learn in this judgment. We thank the court for, being elaborate on the doctrine of vagueness as springing from the rule of law. That it need not be legislated. These are laws of basic decency. So they have elaborated what the doctrine of vagueness is. They have given us more fighting power in defending freedom. Because now you must understand the decision in Obo, it was salutary, but it was a pioneering decision. So there are so many principles laid out in Obo. And yes, there was the military showboaters did not, and their hunger zone tried to kill Obo. But we tried it. We were clever in drafting, and we wanted the courts to state clearly certain principles, and we have achieved them. I think we have had total parity. When Andrew and I we are working through to understand what do we want to achieve, there was much thought. we wanted to achieve, I, I think, I think they have described the doctrine of vagueness as springing from the rule of law, and it embraces two principles. The first one is fair notice to citizens before, during, and after legislation. Now, another generation will build on that, but that's a massive wisdom out there being democratized. This is a wisdom that was left only for lawyers and legal geniuses. It's now being democratized. The court has been clear because we didn't give it much work to do. We asked them, you know, we boxed them in a corner, and they have delivered. There has to be fair notice to citizens, including the last mile citizen, of the content of law, the purpose of law, so that the citizen is not looking at both sides of their shoulder all the time. The second principle has been called, in the language of the judge, the limitation of enforcement discretion. That sounds like very complicated words, but they are saying all authority has limit, must have limits, and if there are no limits to authority, then there is no authority. The law has failed to achieve its purpose. The purpose of all law is to put limits on authority, not to put limits on our freedom. That's that's a very distinctive step in progress. I invite colleagues to agree with me on this. Um, the judgment in its last paragraph, the judge is clear in saying why we disagree. He says this language is so broad that the DPP, the police, those in authority, judges, courts can pick and choose at their own will what will constitute an offense. That is not permissible. That is too much authority. In fact, the word they say, the judge has used the word in making this particular section, in framing a law such as this, Parliament has excessively delegated authority to so many people, and that's not acceptable. That's not how law should be. So I think the court has also said that as a result, there has been, and this particular law enabled the prosecution of unpopular and critical protected speech or expression. So again, we have vindicated the principle of effect. The effect of a law can be the basis for rendering it unconstitutional. Lastly, again, in terms of novelty or step change in the law, with this text alone now, it is very clear that harm, when we want to understand harm, how does harm arise and who is capable of redressing harm? The court has shown that the entire justice tree has been vulgar, to put it bluntly. Police have been vulgar, magistrates have been vulgar, the prosecutor has been vulgar, the courts have been vulgar. Such such clarity should be commended from normative terms. So let us not look a gift horse in the mouth, so to speak, so to speak. It is a massive step change from Obo, because Obo dealt with so many things. These principles, to be distilled from Obo, would take a lecture that probably spans 4 lecture periods. But now it is short. It's about what? 21 pages, but give and take, we're speaking of 8 thorough pages well written. So there's something there. Of course, just to recap, human rights is not politics. I couldn't have said it better than Kalundi did. But if I could, take that conversation forward, the reason we're in this quagmire is not only because of the military. The military structure and laws being made, to serve this hegemony. It has a obvious foundation in colonialism. Hmm? Laws were made to serve the interests of the Bwana, and they were to be enforced by a brutal askari against the Wananchi. These legacies, these pathologies of colonialism continue to date, but they continue largely due to the dishonesty of our elites that have found oases of freedom, and by contrast, repression. They are elites, even on this very space, that are interested and invested in the continuation of repressive regimes. And until this honesty is brought to an end, and I don't know how it's going to be brought to an end unless we exercise freedom of speech. I don't know how we shall exercise this honesty from our elites, and they're not military elites alone. I do not like to bang this thing on militarism. Militarism is not a preserve of Museveni and a few of his cabal. Man, people in churches are militaristic. People in law schools are militaristic. People in business rooms, boardrooms are so militaristic. People in taxis are so militaristic. So uh, we have to be dedicated and careful in the rhetorical force of the activities we
Thank you.
engage in. Yeah.
Thank you, Isaac. Kakai, I know you might want to respond, but could you hold on to your thought and we bring in Andrew and Aaron, and then after you come in, before we go to questions from the audience?
Okay, thank you. It's okay.
Okay. Okay, so Andrew, is this the point we discussed the challenges of public interest litigation that you spoke of at the beginning, and also how human rights activists can sort of maneuver if there's a way, or what is even the cause of these challenges in the first place?
This is indeed the point where we can delve into that question on public interest litigation, but also elevate the discussion to the heights that my colleagues have climbed to. I would like to invite all of us on this space, especially, this is quite something to say, especially those who are younger. I am in ordinary parlance regarded as someone who is young in Uganda because I'm only 33. But we have even younger, much younger people in discussions like this. The average age of a Ugandan today, the mean age of a Ugandan today is 16 years old. So we have people, and I'm saying this especially for my colleague Sulaiman Kakaire, we have people who were not born when the decision in Onyango Bo was rendered, people who were not alive then. And for them, the closest memory they have of the world today is perhaps events like maybe Barack Obama's election, the construction of the Northern Bypass in Kampala, things that we deem or think to be so recent as not to be categorized as history, but which in the minds of the majority of the Ugandan population are actually historical events of note. These people for whom we do some of the things we do, or with whom we do some of the things we do, such as a colleague called Godwin Toko, who was in primary 5 when the Northern Bypass was being constructed, but is now a taxpayer, he's an employee, he has a child. These people, we need to appreciate the shifting demographics. We must be alive to the fact that we have a very young population and therefore whose appreciation of these questions might not be in the same way that we appreciate them. So if you make reference to Zai Gario, who did a lot of groundwork in building the understanding on these questions of political economy, public interest litigation, or people like Philip Karugaba, who wrote papers like Shipmarks and C-Rex on public interest litigation, or even scholars like Mahmoud Mamdani, Joe Loka Onyango, some of the best professors we have in the country and indeed region or continent, we might miss the point and leave behind these people, these young citizens, and I use the word young very respectfully. I do not mean it in a condescending fashion. I mean, I use it to point out the fact that we have a changing country, an evolving population, whose realities we must be alive to and not wash down the drain. So, Agatha, to your question on the challenges of public interest litigation, it is something I have asked another scholar called Businje Kabumba, he teaches law at Makerere. And it is that we have laws whose names are in contradiction with what they intend to achieve. And I'm going to say something risky on this space because someone has, the person I'm going to talk about, has sued me before for 1.5 billion shillings for supposedly defaming them. But we have, and this is the first example I'm going to give, we have a law titled Anti-Money Laundering Act. This is a law that purportedly seeks to crack down on organized, on a notorious form of organized crime called money laundering. Yet we've seen this law instead be targeted at NGOs. We've seen this law be targeted at individuals like myself, whose accounts were closed, and several other people who suffered a similar fate. But the actual launderers of money, some of whose banks have been closed, and for which there are reports that show that these people have engaged in money laundering, are actually swimming, have gone scot-free. The net, if this was a fishing net, is catching small fish, is catching frogs, is catching crabs, is not catching the crocodiles for which we think that these laws have in fact been enacted. So as a public interest litigator, you are constantly faced with challenging laws that talk about public order management, laws that are called anti-money laundering, laws that are called anti-pornography, a law on anti-pornography that seeks instead to police the woman's body and to dictate how long or how short a skirt should be without tackling actual instances of child pornography, actual instances of revenge pornography, which is all the rage in our country today. You have laws that are couched in language that ends up being counterproductive and letting off the actual criminals while persecuting or prosecuting the opposition, people who have different lines of thought that are not consistent with those of the ruling family. So that's an area that can be quite challenging as well. I will mention two more, and hopefully we'll have done justice to your question, Agatha. The second challenge arises from the contradiction, and this is something that I encourage listeners or scholars on this in this discussion to pay attention to and interrogate more in terms of scholarship. The contradiction between what we call a free market economy on the one hand and militarism on the other. So we are told that Uganda operates a free market economy where the private sector is allowed to innovate, to lead on growth, to lead the charge on exploring new boundaries of human endeavor. Yet, what this means is that you cannot. The point I'm making, and I invite listeners to listen carefully. What this means is that you are saying people should be free to innovate, make apps, come up with new types of, computing, new ideas in the market, entrepreneurship, social enterprise, and so on. Yet, at the same time, the militarism is saying you can only go this far. Free speech is free speech ideally should be a component of of a liberalized market, because how else are you going to elicit the views, how else are you going to unlock pioneering thought if you are clamping down on people's rights? So it's an area, it's a contradiction, which obviously ends up impacting on how much public interest litigation we can do, because we are surrounded by very vicious manifestations of family rule, of militarism, and whatever other synonym fits the bill for the kind of situation we're faced with. The final thing, the final point, the final challenge I'd like to point out insofar as public interest litigation is concerned, and which I believe my colleagues here share, is the threat of irrelevance. Let me call it the threat of irrelevance. So there has been right now about 5 monumental decisions at the level of the Constitutional Court and the Supreme Court, some of which have been mentioned here by my colleagues on the panel. Not least Charles Onyango Bo, not least decisions about the Anti-Pornography Act, Anti-Homosexuality Act, decisions that have been rendered about the Public Order Management Act. And we could also use the example of this very judgment that we are discussing today. But there is a threat of irrelevance. And what is that threat? That threat manifests in the sense that we run the risk of becoming talking shops, where we burn a lot of brain power drafting these documents, filing. We spend considerable amounts of money to mount these challenges, and then the court finds in our favor, but the very next day someone is abducted, someone is tortured, someone's toes are ripped out, someone's bank accounts are frozen, someone is arrested without basis. So you have a decision, but there is no change, there's no substantive change in the political environment with which we are faced. And I'm alive to the fact that I am bordering on encroaching into what Isaac was talking about, the dichotomy between human rights and politics. But what does this are we alive to the threat that this presents to public interest litigation? What's the point of continuously getting decisions in our favor, yet we are not translating them into actual tangible benefits for, the everyday Ugandan who does not know where the Constitutional Court is, who does not care for what Article 28 of the Constitution says, or 29, who does not really want to know about the Bill of Rights, but is interested in living in a country that is fair for all. And yet, every time the news says, oh, Karamaji and Robert Shaka have won in the Constitutional Court, doesn't feel a substantive effect in terms of change, in terms of progress in their life. So that way, public interest litigation might become an exclusive club. It might become like religion, where it's an exclusive club of a few that has no meaning to the everyday citizen in whose name and for whom we purport to mount these challenges. So those are the 3 major fears that I have, the challenges that arise in this domain of public interest litigation. And I invite all of us, Ugandans and others on this space, to invest more in actual tangible actions like protest, defiance, and actions that actually push back in real terms against the family rule of General Yoweri Museveni and his colleagues. Because unless we do things like what fellow Africans in Egypt, in Sudan, in the Gambia, in Senegal, and several other countries around the continent have done, we will merely continue in these discussions, armchair analysis that do not scratch or even dent the military rule or family rule that we are faced with. Thank you, Agatha.
Interesting questions, Andrew. I hope we leave this space with answers from your co-panelists and some people in the audience here. And I want to repeat what I took as the last challenge you mentioned. Why should Omuntu wa Wansi right now care that Andrew Karamaji and Robert Shaka, for example, won a constitutional petition? I think that's one of the challenges Andrew mentions. How does it make their lives better than they are now? Thank you, Andrew. We are into the second hour. I want to ask the panelists one last question. Kakwenza, you will come in after we have listened from the audience. We have important people in the audience. Raymond Mujuni, who was supposed to be my co-host and didn't come early. Solomon Seranja. We also have the president of the Uganda Law Society, Counsel Bernardo Wundo, Olivia. All of you, thank you for being part of the space. I'm seeing the people requesting to speak, and I hope we'll have time for all of you to speak. But before we go into the audience, I wanted to ask Aaron Chiza to give us the distinction between this case, the judgment of 10th January, and the Nsereko law. Like I said, the main reason I decided we should have this space is because people were actually thinking that the Nsereko law has been thrown out. Could you make that distinction, but also maybe elaborate on the relationship or the connection between those two? And then we can go into the audience too. Thank you, Aaron. You're welcome. You can take the floor now.
Thank you. Thank you very much. My colleagues have provoked me a lot in a good way, because the very essence of law, the very nature of law is being questioned by this debate. And this specific law, before I really answer your question, we have to understand it the way it is. This law is a big brother law. It was meant by the government to police our thoughts, to police our morals. The law itself was a failure of civilized politics. If we had a democratic parliament, we wouldn't even be having this Twitter space. It is a testimony to the growing making of the Ugandan opposition irrelevant and unable to push back against the interests of the mafia that are running the show in the government. It's an attack, a sharp razored attack on the politics of on democracy, basically, by the political and military elite that are running this country down to the ground. And of course, then the judgment itself, it ventilates the context between the forces of good in Uganda and the forces of evil represented by Museveni and his family, as aptly recalled by Karamaji as family rule. I want to state in very clear terms and disagree sharply with Isaac on any notion that this somehow is not, that militarism is not the problem here, that somehow everyone is the church leaders and militaristic and whatnot. No, there will always be bad guys, outrageous guys, but people in a church, if they behave in a certain way, it doesn't impact us the way our leaders impact us. And there is no denying, there is no even disguising on the part of the political elite that militarism is the most important force governing this country. And actually, this legislation itself, it is like a codification, an attempt to disguise militarism and give it a legislative cover. And even the judgment faces the challenge of being relevant. Its relevance is being limited by the fact that it gets delivered in a political space that has been compromised and is dictated by militarism. It's like we are in a war zone. Laws are beginning to cease to matter. When they arrested Toko, and when we were trying to negotiate for him bond, the policeman said that the problem with you lawyers, you speak English, and for us policemen, when you speak English, we lock you. You will speak your English. So what we are doing here is more like English. It's good to listen to it. And yes, colonialism, of course, was a vehicle, but it's not the root. The root.
We lost you, Aaron. I don't know if you are still on. Am I the only one who isn't hearing him?
No, you
No,
aren't.
I also can't hear him.
Okay, I'm going to bring in Raymond so that Aaron can speak when he returns. Aaron,
Agatha,
is your
Aaron should
microphone
blink.
open?
Aaron should blink twice to let us know if he hasn't been captured.
Aaron, are you back? You can unmute. I think he still has a problem. Okay, so I'm going to allow Raymond to say something, and then also I'm going to allow these two people, the lady Dorian, who are missing ladies in this discussion, and Loings, and from them I will start with Kakairi to respond to Isaac. Yes. Raymond, you can unmute and speak, please.
Hello, Agatha. I hope you can hear me.
Hold on, Raymond. But in the someone can find out if Aaron is okay.
Hello,
Yes,
Agatha.
Ray.
Can you hear me?
Yes, we can hear you.
Thank you so much for this space.
But you are. It's not very clear. I don't know if it's where you are.
It's the earphone.
Try to speak and we see if we can get you.
Both hear me well now?
We can hear you now.
Sorry, I had earphones on, so I had to remove them. Thank you so much, Agatha, and thank you so much to the people that have been at the front lines fighting. I've always said on matters for freedom of expression, broadening them, journalism can't be neutral, neither can we be balanced, because the bedrock of journalism really is this freedom of expression. And we have to expand the frontiers and barriers to freedom of expression as far wide and possible as we can in our lifetime. So great thanks to Andrew Karamagi, to Aaron Kiza, to Isaac Ssemakadde for putting in this fight. I concur very largely with Aaron Kiza. Going to court is a very important and foundational step that we must continuously take. But more important is the culture that underlines our governance system. We, over the years, have remained largely militaristic culture in the way we approach problems, in the way we approach political settlements, in the way that we even approach conflict. So despite the fact that I know we have this fantastic judgment and we wait on another one on the amendments that were made to the Computer Misuse Act, I don't imagine that the culture that underlines the freedom of expression, the culture of militarism that the state uses, I don't think that that culture has been wiped out. And this is where we must consistently engage with state actors, oftentimes bash heads whenever we can, oftentimes insist on with as far enough platforms as we can, so that we inculcate into our state practice a culture of respect for constitutionalism, really a culture of respect for the fact that we have a constitution, that constitution guarantees freedoms which are inherent to us. So I thank the activists so much. This is just one of the many fights that we will continue to have. I think that moving forward, we still have to engage with the fight on getting the culture, the political culture of respect for the constitution and constitutionalism. Even if we have a militaristic government, we have to insist that the culture shifts from that militaristic approach to a civilian approach to the conduct of public affairs. And I see that we have some members of parliament on this platform. And I've always felt let down by parliament, mostly because as an institution, there are responsibilities that are due to that institution called parliament. Responsibilities that can't be negated, responsibilities that cannot be played by any other party except that parliament. And for the members of parliament in this space, really look in the mirror tonight and think long and hard to yourself. Am I playing the responsibility for which I am in this August House for? It's one thing to get your paycheck at the end of the month. It's another to play your responsibility in the growth and development of a country. You need to ask yourself, what will it look like for my children, grandchildren, great-grandchildren? Because if you don't fix the problem now, that problem then is passed on to your grandchildren, then to your great-grandchildren. And it's sad, Agatha. I say this because in my own family, 4 generations of men have been involved in some form of civil warfare to sort of guarantee some level of freedom in this country. From my great-grandfather, my grandfather to my father, all of them have been engaged in some level of civil warfare. And you imagine I, their son, now getting engaged again in litigation and fights to make sure that we guarantee just the basic modicums, things that are inherent to people. So for me, I think the problem is culture, but I also think that in inculcating that culture, the biggest responsibility falls to Parliament of Uganda. And I jokingly tweeted, but I think that it should now be important that they should attach this Charles Onyango Bo ruling together with the Andrew Karamagi ruling. They should attach it to the swearing documents of members of parliament, because we are tired of getting into this fight over and over. Every year, the Constitutional Court has to keep reminding parliament or reminding someone within the echelons of power that these are inherent rights of individuals, rights for which a constitution guarantees, rights for which can't be wished away. And that for me is the fight that I'd want to be engaged in, the one on really working on the political culture of our August House.
Thank you, Raymond. Raymond and I are always planning together. We planned this together. He was the one supposed to host it, but became a busy person of late. I hope you can share the money with us who are on the front line.
It's poverty. I can share with you the
Aaron,
poverty, Agatha.
Aaron, you're welcome back to the space. Please conclude your thoughts. I hope you remember what you were discussing at the moment.
I'll hopefully just go into conclusion, and I want to ask what else you and my friend are always planning beyond what you have told us. I think one thing we agree about on this I was about to call it a show on this space, is that the computer Section 25, offensive communication, was bad as a section, and the Computer Misuse Act of 2011 was generally bad. There is also Section 24, which we hope that the annulment of Section 25 will lead to the annulment, the subsequent annulment, hopefully again quickly. I want to sort of answer your question about the distinction between this and the serial law. It's just that the serial law is worse. And while the most obnoxious sections of the 2011 law were Section 25, which has been annulled, and Section 24 on cyber stalking, the entirety of the NCRECO law, that's the Computer Misuse Amendment Act of 2022, it will have to go. There is nothing to save, because each and every, there are around 6 provisions. They are unnecessary, they are all vague and unnecessary in 2 ways. One, they are undemocratic, and 2, they are all a duplication of existing law, making them a complete waste of taxpayers' money. But we must know why they came in. As bad as this law that we have got rid of is, and although it gave some color of law to the harassment of the likes of Kakwenza, Stella Nyanzi, Andrew Karamaji, Robert Chaka, and so on and so forth. The military elite, and forget the political, we don't have a political elite in Uganda beyond the military elite, because the politics here do not matter. The usual politics here do not matter. Everything is controlled by the gun. Everything is controlled by violence. Right from 1986 to the date, only that it gets worse every day. So they were disappointed. They felt that this was not biting enough, that this law was not strong enough, and they have been clear in stating it. So they brought this Nserico law, so that any nut that was loose, so that instead of having only about 4 exilees, now we are going to have a whole bus, including people in Europe, going out of the country, because unless and until the Constitutional Court does us and itself a favor of annulling it. I wouldn't, of course, want to go into the nitty details, but the Nserico is brief, around few sections, all of them outrageous, each of them independently very outrageous, and each of them worse than this one, except the one on children. But then even that one is unnecessary, because there is already a whole act on children and a litany of offenses there that protects children. I could just comment a few, 1 or 2 things about the challenges of PIL. One thing, because we are operating in a very murky waters, whereby imagine a petition filed in 2016 and decided in 2023. That's a long time. PIL suffers, and I know Isaac, for him, is more open about it, but not many people are open. There is little resources. To support PIL. So Ugandans need to invest more in the process of PIL. There are many obnoxious laws we could probably have got rid of. There are many things we could have challenged if we are supported. I don't want us to delegate the function of funding this to some donors, because the donors are few and their conditions are stringent. Ugandans must fund their protest, including both the political and the legal protests, the legal maneuvering through courts. Any question?
Aaron, so sorry, Agatha. If I may buttress the point that this is Karamaji. If I may buttress the point that Aaron has just made about the cost of litigation. So
Okay.
I often receive messages. Omugaga ulina sente, like rich man, you won in the court, you must have a lot of money. It might come off as surprising, but it's actually true that these cases are filed, drafted, and paid for the things that whose costs we cannot avoid, rather, these costs are paid out of our pockets, the litigants, as well as the nobility and goodwill of lawyers who take time off their schedules to actually help argue these cases. Donors as well, I'll say this so bluntly, donors do not understand, much less appreciate the importance of public interest litigation, and they always want you to fit within a box that is just not appropriate for this kind of work. And so there's no funding for these efforts. Of course, it's also not, it would be immodest or immoral of us as public interest litigants to seek costs, because we would be putting those costs on the taxpayer, ultimately, the already overburdened taxpayer. So we do this out of just your love for your country, the hope for, to make a contribution towards the democratic project of your society. So it's an open invitation to all Ugandans to view this as something that they should invest in. We must invest in our freedom. If we have money to, spend on the kinds of social activities that I see going around on social media, we certainly can spare a coin or two to support public interest litigation. Thank you very much, Aaron, for making that point, and I apologize to Agatha for speaking out of turn. Thank you.
No problem. Aaron, if you could conclude your point.
No, I'm done.
Okay. Thank you very much. So I want to allow two speakers, and then we will get back to the panel, and I'll begin with Kakaire then. So Kakaire, you are going to still hold on to your point that you wanted to respond to Isaac, and then also pick up some of the questions you could respond to from the audience. We're going to start with someone called Lowlings. You can unmute your mic. My co-host also, if you want to speak, don't let Karamaji intimidate you. You can also speak at some point if you wish to.
Okay, thank you so much, Agatha, and the all panelists, co-host, Mr. Kakwenza. You're highly welcome. I will just speak a little regarding this Computer Misuse Act. I hear everybody is calling it Nserekolo. This law, it's there to help Ugandans, because we have seen that computer misuse. Am I muted?
Sorry about that. You can continue.
Okay, I thought Mr. Kakwenza has taken me. Thank you so much. So let me say something. Let me say about this. So Computer Misuse Act, we see that in 2021 elections, we have seen that more people were misusing computer. They were posting different things. So we see that the government of Uganda came up with this, that they have to review on a computer is the bill. They have to send many MPs so that they can review that one, but everybody is calling it Nserekolo. It's not Nserekolo for that. It's a government. It's comprised of many MPs. They have gone there to review that. So let's remove that of saying that in Nserekolo. Then if we look at the 1995 Constitution, someone has highlighted on 1995 Constitution that it was comprised of many generals. Yes, we see that there are some loopholes. So they have to go back and review all the Constitution of Uganda. We see that it's not helping Ugandans at all, and including this computer misuse. If we look at nowadays, if you go back on social media and see how people post, how people use their social handles, it's not really very good. So we will not call it Nserekolo, and it is more useful to Ugandans. So people, you have to the bad thing it is with that law, it's not comprising opposition. So they have to engage with opposition and see what can we do to help Ugandans so that they can use their social handles very well. Thank you for listening to me, guys. I'm Lawrence. Please kindly follow me. I'm representing Vanyachitara Empire.
Thank you for your
Agatha, why don't you take written questions?
Sorry?
Because people, why don't you take written questions and be selective about who you
No, it's
waste
okay.
valuable speaking time on? Because
Let
Okoli,
him
let me.
Lawrence
speak.
is
Let him
purely an
speak.
anarchist. He's purely militaristic. You know, he doesn't give examples about how
But
handles are wasted. He doesn't accept the validity of a judgment
those are
from
the
the constitutional
questions.
court. You know, he's
Isaac,
speaking in defiance of a court ruling, and we're talking about promoting constitutional culture, and you're just sitting there allowing him to think it's okay. Please be critical and firm in telling him that he's a bullshitter.
Isaac, those are the questions anyone
No,
would
it's a
ask
duty
a
on you
respondent.
now. There's a judgment
No.
which has come,
I
and
am not
Lawrence
going.
doesn't understand it. Explain it to him.
I am not going to
Please
gag
disabuse
anyone.
him of the stupidity of this notion so that he doesn't
No,
continue it in other forums. I beg.
I think the value of why we are here to respect freedom and promote it is that he will say even annoying things and we will take them
Exactly.
and accommodate
No,
them
I'm not
and
annoyed.
have it
I'm simply
clarified in the
saying
debate.
he's
Can
saying
I,
things in
Isaac?
defiance of a judgment,
Isaac.
and we who know we have a duty now, a constitutional
Exactly.
one,
So,
which is
so we
imposed
have a
on one of
duty,
us to
Isaac.
tell him,
We
to disabuse him of this.
we have
We
a
can't
duty
just
to
laugh and
respond to
just say,
him, but not a
yes.
duty to shut him up, to stop him
We have
from
a duty
saying
to
what he
disabuse
wants.
him, not even respond, disabuse him, because he has
Let us
unconstitutional
continue.
views.
Can you
He
note
doesn't
down what you want
understand
to disabuse
constitutionalism.
him of?
Most
Can
Ugandans
you,
do not understand constitutionalism.
Isaac? Please note down what you want to disabuse him of, and you will respond, please.
I have had
Oh,
my turn. It's okay.
Okori James, please unmute your microphone and be precise, please, in your question. If Okori James is not available, Brian, you can ask a question. I have accepted your request to speak. Okori, are you on? You have requested to speak since the space started almost. I thought you had something burning to ask or comment. If you are on, please unmute your microphone and speak. Okori is not on. Brian, can you ask your question or make your comment? Brian Akankwasa, yes. Well, I don't know what the problem is with the people that have requested to speak. Brian, if you can, please go ahead. If Brian cannot, Mugabe, you can unmute your microphone and speak.
Yes, Agatha, can you hear me?
Yes, we can.
Okay, yeah. I think my comment is in relation to this issue of freedom of speech because I think it cuts across. On one hand, lawyers are meant to come in and really see that courts of law really do the protection of the rights. But again, when there are some legal, enactments or legislative developments or reforms which seems to be retrogressive or sort of carving inroads in what should be the freedom of speech, I think that becomes a concern. And I think even when we are in the spaces, the freedom, the liberty people to say what they want to say, the way they want to say it at any time in any way, I think it becomes very crucial. And I would just like to get maybe a comment from one of the presenters because we do understand that the regimes of human rights are varied. They are quite distinctive, but also varied in terms of being, there are those where the state has to respect. There are those rights which the state has to promote, but there are also those which the state has to actually preserve. But from what I have heard from some of the colleagues who have explored and examined the legal framework of the Computer Misuse Act, because again the court judgment came out, but there are mixed feelings, very very mixed feelings in relation to the outcome. I would be just more keen to understand, according to the different presenters, do you think the law itself in the first place shows that we're having an approach which is diverging towards human rights or which is converging towards human rights, and what could be the long-term solution in terms of such legal developments across the national landscape. Thank you, Agatha, and thank you the different presenters.
Thank you, Ivan.
Good evening,
Yes,
colleagues.
Good evening, Brian. You can go ahead. Okay, it seems Brian has gone off. There is a hand, someone called Wamugadi or Mungadi. Please, you can unmute your microphone.
Isaac Ssemakadde answer back to at least one of the people, but that helps me to bring in my point that some of us who have recently moved to the United States, the citizens take the law seriously because the military, the police is so hostile, but the citizens are encouraged to know the law. And it is said sometimes the citizens are called upon to defend the law with their blood. So the citizens must know the law. I liked the anger, if it is anger anyway, that Isaac has answered. We just have too much comedy. There are things that now require that we as citizens of Uganda are serious and know what the law requires us if we have to defend it with our blood. Thank you, Agatha. And thank you, Isaac, for that toughness. Yeah, we need that.
Thank you. I'll accept two more people here. I had accepted one called Motive, but he has gone off. But Karim and Musa, whoever can unmute first can go ahead. Yes, Karim.
Hi, thank you so much, Agatha, and thanks so much for the panelists. I want, first of all, to congratulate on the win in the Constitutional Court. I mean, it might look like it's something small, but in the grand scheme of things, you have set the precedent. And I think often at times, the regime assumes that free speech should only be when people are singing praises. But my observation has been that the true test of freedom of speech and expression is not when people are clapping and singing praises for you, but the ultimate test of freedom of speech is if you can uphold it when people are saying humiliating, painful things about you. If you're willing to hold free speech to that, that's the ultimate test. So I am glad that Counsel Ssemakadde and Aaron Keys and Andrew Karamaji at the forefront of challenging the Ugandan government on that front. And we will be looking forward to partnering with you and working with you where you might need assistance. So I will stop here. Thank you so much.
Thank you very much, Karim. Motive, I can see your own actually. I thought you had left. So it's Motive and then Musa, and then we'll get back to the panelists to wrap this up.
Yes, Agatha, thank you. First of all, good evening, guys. I'm happy that we made this, and to thank everyone like Counsel Isaac and all the team who made it possible to see that shit has nulled out. Like me, the question I have, there's like me, I'm sorry, I'm not good in English, but I will try to do my best. For me, I was
I
a
think
victim.
we can allow Luganda so that we don't miss your point.
Oh, okay, thank you. Like the Bankwata, Nevanto Charinga, later I brought to court and charged with Section 14. I don't know whether that's where I need my That's where my question is. Njagala kumanya nti ku guidance y'aba council nti oba nakyo banaakikolako kino tusobodde kituukako kati tusaba ne obusigaddemu obwo obumulumulu nabo bwetaaga bukolebweko. Tukimanyi nti dictator tetusobola mukuba kyenda kuba ayina obuyinza bwonna asobola otutta so tukola ki naye at least bwe tujjawo obwo kuba naye alina kye yeekwasa nti atulugunya n'agamba akozesa amateeka naye at least obwo bwe bakozesa singa buvaawo kijja tuyambako mu funzo oyo gaye. Thank you.
I hope the panelists have got your point, motive. Musa, you can unmute and ask your question. Be brief. And we'll go back to the panel and see if we'll have enough time to listen to the 3 more questions I see from the audience. Musa Nasri, are you online or should we continue? You no longer have the comment you wanted to share here. Okay, back to the panel. Kakaire, you can start with the response you had shelved earlier, and then answer some of the questions that came from the audience.
Thank you, Agatha. I know the question. That's why when I made my thoughts public about some of the things I've said, I know that some people may not understand them now, and that is acceptable. But you realize that I know this panel has many of lawyers. There are many lawyers. Make it known to the public that you see the principle that Isaac is referring to, that the court is clarifying the principle of vagueness, was discussed extensively in the Supreme Court. If you read, that was ground 3 of basically in the summary of Mulenga, when he says that the points under contention in this appeal are about 3 things. It starts with the first one, that whether false news is demonstrably justified in a free and democratic society. Then ground 2, whether it's part of existing law that must be construed in terms of Articles 273 and 274. Then he goes to the third one, whether Section 50 is vague. And they discuss in extenso the principle of legality. It's called the principle of legality. Also, which is also enshrined in Article 28.812. So basically, the court in the Supreme Court had clarified it. My question to people like Isaac is that when we say that the court in the recent judgment, this week's judgment, it is clarifying that we are missing the point. It has already been clarified. But what we should be bothered with is why the court, why the political institutions, even when courts have clarified the principle of vagueness, they continue to legislate provision in a vague way. And that question can only be interpreted if we broadly look at the political context, social, political, and economic context within which laws are formulated. But I know where the crisis might be coming from is the perception that human rights can be excised from politics. If you just look at discourse on human rights, when it emerges in the contemporary social and political thought, people will, those who are familiar with the debates which are happening, starting from the pre-capitalist, not the pre-capitalist. I'm looking at starting from the Lockean age, when they start to debate it. There was that attempt, and that has been the legacy that has been bequeathed to generations after and the way in which law is taught. The thinking that law can be separated from politics is wrong, is a misnomer, it's misguided. The reason why the private citizen is trying to be, there is an attempt to separate him from the political institution and make the state as though neutral. It is the dilemma, which is an illusory. And me as a left wing, I'm not mistaken about that. I'm not misguided in that thinking, because I understand law is, and our analysis of law must be appreciative that it's born out of a contestation. There is a particular group. Just to give you an example about the communication space. Communication space is not a neutral space. It's a space of which is defined with a struggle over meaning, over representations. Meaning over representations. There is a struggle over meaning. For those who know, those even with basic study of communication studies, that is, which is beyond the novel of just looking at a communication process as a sender, receiver, sijui a message. There is a lot of dynamics which are shaping that. And that conversation starts way back, starting from the niches when they are looking at ideas and opinions as things that are neutral. But we can have that debate later. So when there is an attempt of even saying, because I've seen the crisis among lawyers of saying, this provision is vague, this one is what? The petitioner themselves, they said it's vague. The government lawyer is saying that, no, it's not vague. Now the judge is saying that, no, it's vague. There must be clarity to define it. But in communication, you can't clarify anything. Because a communication artifact, which is an idea, opinion, or anything, it can't be objective. Information, for instance, we are talking about sharing of electronic communication, which has a potentiality of disturbing. I may share an opinion to you with the audience right now, and it may be disturbing to one person, but it's not disturbing to another. It is also setting up peace for another. So there is a variability in respect of how information is conceived. And that's what I'm talking about, struggle over meaning making and production of meaning. It's quite a complex process, which is beyond the purview of law. And the debate, it goes back to how is law thought about in legal theory. We know very well in your novel law school understanding, these are questions of jurisprudence, which are not reducible to a mere one view of the law. And we have disagreements over that. So I would also like to contribute. Indeed, I agree with Aaron and Andrew, who also eventually agree with me that after we've understood that law is not neutral, and that when we continue to make these judgments, how come the abuses continue over time? I've seen Senior Counsel Philip Kalugaba, since he started to litigate over environment. Did the degradation of the environment stop? It didn't, because the politics and the economy within which we operate, it subordinates the law to its interests. And that's how the modern state is defined. And the modern state, obviously, I'm not oblivious to the fact that the modern state does not start in 1986. I'm much alive to that, because I can't be a student of political economy and cultural studies, and I'm not alive to that. I go back to Westphalia, but even before the Westphalia conversation, and how over time it has evolved, and even the discourses that have been bequeathed to us through legislations of Chapter 4. But you will understand that that modern state, it must be historicized in its context. In the context of Uganda, the modern state is a military state. You can't compare it. The nature of military involvement in Uganda, it's not comparable to that of Tanzania. It's not comparable to that of the Scandinavian countries. We have to be cognizant of that historical context and the motion of the historical process, how it has shaped and defined the states in their respective and specific contexts. And for the case of Uganda, you can't ignore that fact. Andrew poses a very important question, which was part of my preamble, which I found even in the case in respect of my investigation of the impact of the judgment of Charles Onyango Bo and Andrew Mwenda as to the operations at Monitor and New Vision. My master's thesis, which was supervised by Professor Joloko Nyango, my major finding is that legal activism is limited, and that the expansion and emancipation of the communication space must be connected to the broad struggles of democracy. You see, I'm not saying it's not reducible. And to connect it to it's the conversation which Andrew is saying, that, okay, jurisprudence, we can do things in public interest and there is jurisprudence. But what does it mean for the ordinary person? That is the major question. So does that also pose a question to us, that how do we think about public interest litigation? Is it merely thought about as a mere struggle in the precincts of the courtroom, or it should be thought about broadly that this is a struggle over questions of equity, social justice, which must be broadened? The conversation must happen at the public square.
I didn't know I have been
That's
speaking
where the
alone.
conversation must be. And I absolutely agree with
Kakaire,
colleagues who are
we
ready to
lost you.
understand it in that way. So
We lost you a while back, but please
eh,
conclude.
so my thinking is that we should, right now I've been I'm an activist. I've been in the space of activism in the trenches, but when I decided to come and do the PhD, most of the questions I've thought about is, do we need to rethink about how social movements are conceived? What questions are we posing? What are we doing right? What are we doing wrong? And those are the major questions. And to answer those questions is that we must broaden the conversation beyond the precincts of the law. Thank you.
Thank you, Kakaire, for that. And I'm going to ask Isaac, Karamaji, and Aaron to come in and respond to the questions from the audience, but also in case Isaac wants to respond one last time to what you have said, Kakaire. And I'll ask again if my co-host Kakwenza wants to say something before we come to a close of this space. But also, I'll take one last question if you send it to my inbox, Samukuru. Isaac, please, you have the floor. 2 minutes each.
Can you hear me now?
Yes, we can. Yes, Isaac, we were hearing you, but you are muted now. Unmute your microphone. Yes.
Mic is off. Mic is on now. All right. Well, I have a very short reply to Mr. Kakaire. The citizens whose agency you are usurping are here on the space. They went to a court. They won. I don't know what other citizens you are talking about.
Isaac, the question is how are we directing that agency? I'm not structuralist in my thinking. I'm talking about how are we directing the agency.
In fact, for me, it is how you are misdirecting the agency that you're talking about. Because in your long monologue, you have not at all identified any of the roles that those that identify as the political tip of the citizen sphere are involved in trying to defeat militarism and a lack of constitutionalism. We talked about this at the beginning, and I said usually in such spaces, no criticism is reserved for Kizza Besigye, Bobby Wine, Mpuga, and all those that occupy the front and center of opposition politics, which should be the alternate government. Why do they outsource this heavy lifting to us? And then at the same time, their praise singers like Kakaire call our efforts minute and insignificant. This is a question I posed at the beginning, and I said it shall go unanswered, and it has gone unanswered. Of all the petitions that have been filed in the Constitutional Court against the Nsereko bill, there is none by any corporate registered political actor. None. Which would mean that if we were to cast a vote, it means that the National Unity Platform supports the Nsereko bill. It has not registered its opposition formally in the minimum parameters of legal formalism. Now, let us see, where is their opposition in the so-called direct political action?
To first,
We don't see it.
Isaac.
Am I clear?
Isaac, we have not been hearing you actually.
Oh, where did you stop? Because I was quite in the zone.
I could hear Isaac. The challenge could be, the glitch could be on your end, Agatha.
Who else could hear me? Did Kakwenza hear me? Hello? Yeah, my question was a simple
Actually,
one.
for me, I heard you properly. I don't know, maybe.
My question is a simple one. That in Kakaire's long political discourse, why has he reserved no mention for the inaction of Kizza Besigye and the FDC, of Bobby Wine, Honorable Kyagulanyi, Robert, and the National Unity Platform? For them,
Because
do they not believe in constitutionalism? Maybe that's what it means. It means that
no,
even those, Kakai, let me finish my point. It means that even those who seek to topple the military regime you call also want to govern by militarism, because their current actions show that they do not want to participate in the struggle to change political culture. They believe. What do they believe in? Because we don't have demonstrable proof of what they believe in. All the citizens that have risen up and decided to bear the cost and the brunt of fighting this regime with means that can cause real change are not in politics. Agatha is not in politics, but she's a petitioner. Andrew Kamaji was in politics, but they were petitioners. We have written several memoranda. We have whispered, we have written text to those who are in
for
politics, and we have
clarification,
told
those are
them,
political activists who have decided not to just join political parties, but they are political
please,
activists.
we are talking about citizen civic duty. And I'm saying that why is civic duty reserved for some and not others? That's the question I'm raising. Secondly, I don't want you to say that we have done nothing for citizens. Robert Shaka was charged with this offense. He was the state of Uganda marshalling all its coercive resources. It imposed on him a charge, Kakayele, you don't wish to be brought on you, that you, Robert Shaka, are going to pay for all the sins of TVO since he emerged. What else was he supposed to do? You know? And he's even lucky that he had good friends like Nicholas Opio, who brought us on the table and talked to us on civic duty. No pay, nothing,
And
but we
Isaac,
said,
you know
well,
very well. For the facts,
yes.
Isaac, you know very well. Robert Shaka's solution, remedy, primary remedy, was not in this
I
judgment. It was after guys negotiated the asylum for him. Let's be
What do
honest.
you mean?
okay.
Let's have
What do you
honest
mean?
I'm going
conversations,
to
On the
colleagues.
guys.
24th of
Yes, let's
Kakwaide, you're
have
not in court.
honest conversations.
I think Akaido just scratching your balls. On the 24th of February 2016, we got a stay of execution for Robert Shaka. This judgment means a lot for his involvement in civil society, in life as we know it. You know? If he's to get,
Isaac
he had a,
and
he had a pending
Kaka,
charge. It's now gone. And I want to move away
Isaac,
from that and say,
if I may,
mhm.
I can you continue this discussion later? Can we finalize and then?
Now let me finish my question. Motive,
And I'm not saying it's not
Motive Kasaga,
interesting. It's very
Motive
interesting.
Kasaga
Yeah.
raised the question which begs an answer, which Kakaire cannot answer because he's infatuated with his
Please
lofty
answer it,
ideals.
Isaac. Please
Can I
answer
answer
it.
it then? So for Motive, Motive has been charged with what he called Section 14. He has told me about it before. I know Section 14 because I know every section of the Computer Misuse Act. This is a section for hackers. He's been charged with unauthorized tampering and access to passwords of others. Now, this is very important. Ugandan banks, year in and year out, continue to report in their own financial statements and elsewhere, and that the UCID police, that they lose billions of Ugandan shillings through hacking activity, which is out of this country. And therefore, the police feel that, they lack the resources. Although they actually can find the resources and fight these crimes. But we see that the Ugandan police and the Ugandan prosecutor do not feel that there are enough procedural safeguards for the citizen, that they can just pick a charge like this one, which should be put on real hackers. They're putting it on Motive, whose only crime, I think, was to call what? To call the speaker Carolite or something like that. They have just put on him any charge. And we see what's the response. I think is being represented by somebody who has not challenged the DPP on lacking even the mere minimum evidential threshold for the decision to charge. So the man is carrying around a charge for which there is not even an iota of evidence. So he didn't get protection from the prosecutor who he pays. He didn't get protection from the investigator who he pays. He didn't get protection from the lawyer who I think he pays. He didn't get protection from the magistrate. These are procedural safeguards which can only be answered by legal alertness and not political loftiness and so on and adventurism. Let us not confuse those two things. Political adventurism, if we want to discuss that, we shall get a forum for it and we shall be more clear. But today we are talking about legal adventurism and its implications. It helps people. Karamaji's concern in this particular matter was one singular, unbridled prosecutorial power. Unlimited prosecutorial discretion has to be put to an end, whether it will be the Constitutional Court, the High Court, the Magistrates Court. That's it. We went to the Constitutional Court only because we couldn't find an appropriate check on the DPP's power decision to prosecute. Nicholas is a good negotiator. He had tried to stop these charges with the police, with everything. The charge was still brought, and all the inspectors were saying, Nicholas is beyond our hands. The state must do something, be seen to do something. So they knew that they were slapping on an innocent person charges that would never stick. So, and I think for me, my concluding call is that in this particular case, we have shown, we have presented a substantive safeguard, but we need more work has to be done to bring procedural safeguards to target particular individuals that are militaristic. Now, Aaron mentioned something. Aaron, I did not say that militarism is not a real problem for Uganda. No. Please don't go with that. Isaac didn't say that. I simply said that there are so many people who find no problem with militarism. From Museveni's family rule and down, their minions and hangers on, they find no problem with it because they benefit from it and they have begun to mimic it, or they have mimicked it for so long that is their normal. And we live with them, we shake hands with them, and we don't call them dimwits. So they actually think they are very clever people, they are very smart people, they are very rich people, they are blessed of God. That is why we don't even challenge the DPP's legitimacy. How many people have challenged the DPP, the current sitting DPP? It's only Legal Brains Trust, which thinks that this DPP is wrong. We got a judgment actually. Kasango challenged the DPP, and he won. This lady is supposed to be out of office, but there's no public hook about it. Hmm? Is she a judge or did she cross? And she's now a fucking political operative. But we continue to bless her. She goes to these Ugandan Christian lawyers fellowships. They give her awards. They give her these things all the time. But this is an instrument of militarism. We
Thank
can
you,
cut it
Isaac.
off.
I,
But if you're
I
not ready to cut it off, then don't start speaking of creating political change. Don't pick and choose militaristic instrumentalities. No. Cut the whole tree, branch, leaf, everything. So we'll discuss that later. But let us be more guarded, I think. Rather than beating around the bush
I am
aimlessly.
I am going to say that Isaac and Kakairi can finish this discussion later. I would like to be present when you're finishing it, but we cannot finish it here now. Andrew, I was asking you to come in and respond to. There's a question that also came in my inbox asking about what can we do if the courts of law have made decisions that have not been respected. And it is coming from Brian Akankwasa, who says the judgment is good, but we've had judgments like this before, especially with the POMA provisions that were nullified but were not respected. What can we as litigants and activists do to ensure that the rulings of court are effected? And you can also respond to any other question from the audience that you want to respond to.
Great, thank you. So today's discussion, this evening's discussion, has correctly refused to be confined to the four corners of the judgment that was rendered by His Lordship Justice Kakuru and all the others who agreed with him. This discussion has really been an assessment of the health or lack thereof of our democracy. And from all panelists and contributors, even when there might be some points of divergence, it is apparent that these questions go beyond or transcend the legal questions we're faced with, so that public interest litigation and attempts at enforcing judgments is merely but one component of the struggle to have a democratic dispensation or democratic society, a democratic culture within which we live and operate and work. So over and above securing judgments in favor, we as citizens have constitutionally protected rights to protest, to petition, to write, to sing, to organize politically, to do whatever it is we should do and must do, because these rights anyway have never been won on a silver platter. So it calls for a lot more action than litigation, than writing. We have to engage more and view this as Momongadi said earlier, view this as a political project that has to be prosecuted beyond, over and above the boardroom or beyond the courtroom, and indeed, as I mentioned earlier, as our brothers and sisters in Sudan have done, in Equatorial Guinea, in the Gambia, and several other countries. So I would really want to underscore that point. My colleagues have dealt with the other questions, and in the interest of time, these dear citizens have given us more than 2 hours of their lives. I would just like to conclude my submissions by saying we need to do more in terms of challenging these manifestations of misrule, of family rule, of militarism, because those who won the freedoms that we currently enjoy did not win them merely by litigation. In fact, in some cases, there wasn't a court to go to. So there wasn't even Twitter to hold a discussion like this and help people understand. But people nonetheless won the freedoms that we currently enjoy. Ignatius Kangave Musazi, Rhoda Kalema, Grace Ibinjira, and several others. So we
Augustine
haven't been,
Kamya.
yes, Augustine Kamian, and so on. So we haven't been an easy lot to moderate. It also hasn't been an easy discussion. It was always going to be contentious. But hats off to you, Agatha and Kakwenza, for doing a great job. And holla at all the listeners and contributors. Good night for now, and great rest of the day for those whose for those whose time zones are still in daytime. Thank you for having me. I look forward to future conversations that are helpful to the building of our democracy. Thank you, Agatha.
Thank you, Andrew. Thank you very much, Andrew, Isaac, Kakaire. I think Aaron left midway. Thank you, everyone who has been part of this audience. But I am seeing Nicholas has just joined us, and Remy also rejoined. I would give each one of you a minute if you want to say something about it. If you don't, we can call it a night. Yeah, I think everyone is satisfied with this conversation, and future conversations we'll have. My friends and I started a platform called Agora for public discourse, and we'll be having these conversations every now and then when there's a need to speak about issues of national importance. So we'll have them. Some of them are on this platform. Toko Murunji, Henry Otafire, and others. We want to be bringing this conversation to the people. Nicholas, let me accept your request, and we. Yes, Nick, I've now added you as speaker. You can maybe give us your comments on the judgment and the fight against human rights violations in general, but very briefly. Yes, Nicholas, you can now unmute your microphone. You are a speaker now. Does anyone hear Nicholas, or am I the one with a problem? I don't seem to hear anything.
I think he's still muted. He needs to unmute his micro.
Can you hear me now?
Yes, we can.
It is still an absolute challenge with these spaces. But I was just saying that I joined the conversation at the very tail end. It's just midday in my time zone, and missed out on a lot of the things that people may have said. But I wanted to use this 1 minute to thank my colleagues, Aaron, Isaac, Andrew, and everybody else who really put in time
Agatha,
to ensure.
if we can't hear Nicholas, perhaps I could say something that I lost in the
We
kerfuffle of the
actually
battle with
can hear Nicholas, Isaac. We can hear
You
him. I
can?
don't know why you can't. Yeah. So you can come in after. Nicholas, please continue.
Yeah, I wanted to take this opportunity to thank my colleagues with whom we worked on this case, who put in long hours, who sacrificed to ensure that we got a decision that we got from the courts. But I wanted to encourage people that let's stop pontificating. Let's get beyond talking. Let's roll our sleeves and do our bit, whether in politics, whether in the media, whether in the legal sector. All of these are efforts that cumulatively will bring the change we all desire. It is not a competition for any credit or for space. Rather, it is a contribution towards what we see as a free, fair, democratic society. And so channel the passion that you have, not to belittle others, not to abuse others, but to cause change in your space. If we all do this, we'll have a much better society. The law may have been struck out, or sections of the law may have been struck out, but the work is still, a lot of the work is still ahead to ensure that these judgments are implemented, to ensure that people understand their rights. And so it's just an invitation to everybody to move beyond lofty speeches to actual work, roll your sleeves, and be able to contribute positively. Thank you, Agatha, for a wonderful discussion, and good evening to all of you, and good day to those whose time zones are still daytime. Thank you very much.
Thank you, Nicholas. I still see so many requests on this, but we have to bring it to an end. Isaac, you had something you wanted to clarify or something before we close? Isaac, can you hear me? And for the rest of the people here that are requesting, you can just send me a DM. I see even Motive is requesting to speak again, but if it is about the question you had asked about your case, you can DM me or any of the panelists that you want to ask. I think we have really spent a long time on this. Thank you, Isaac, for being part of this. Thank you, Kakaire. Thank you, Karamaji. Thank you, Kakwenza, for hosting with me today. Thank you to the listeners. Thank you, Juliana. Thank you, Counsel Jude, Mugabe, and all of you who have been with us since we started this discussion. And the discussions will continue. We will be organizing more of these. I see my co-host wants to say something as we close. You can say something and also close the space.
Thank you so much, Agatha, for organizing this space. It was wonderful. I really have nothing more useful to add. Everything was so perfect. And I really loved it. Thank you so much, and have a good night, everyone.
Thank you. Thank you. The discussions will continue. Thank you all for always making time to be part. And we can always discuss and look for ways forward. Kakairi and Isaac, I still want to look for you